Okay, while he's working on setting up the for the PowerPoint, I would like to get started. We'll wait for the drum group to get back in here. But before we do that, I would like to mention that this day school class action was also worked along with a great friend of mine, and he was a warrior. He was a great, person that fought for our rights as day school survivors. And his name is the late Gary MacLean, Gary Leslie MacLean. He came into on the team approximately in 2008, and we need, I would like to ask the elder, I forget his name, I apologize, if he would come forward and he would say the opening prayer. And before he does that, we'll take a moment of silence to honor and remember Gary MacLean.
Before we start, for a few moments, let's remember Gary MacLean from Lake Manitoba First Nation. Now, let's pause for a moment. Before I pray, I'd like to introduce myself. Gerald Plumtis Neegas from Bimichikamak. I'm a residential day school survivor myself, and I agi pelpikichik no moso maganogon. I want to go to school. As I said, my name is Gerald Plunk, and I'm from Cross Lake. And I was raised by my grandparents, so I got to go to school at the residential day school. But I'm here to say a prayer. I'll pray in the language that I was raised from. No tawi kistikisiku kaya in kau cakap mea kota si mega kap mutia kap matsia. Sawa ni mako kage no. Kaya kisinagis kaya tantawi yatchik mina mga kanochita ni wak o ta ispanik oma ta sapo panik akakimanta mo tsong panik nikiskanitin akasunya taki tawi kwa makapogi naman to makakipakusanimit nan kakinakikuan ta sapo panik kaysa pakusanimwak. O mina dasanya matchikaya o testamaki mina o kikaya so takaya chikaki o pinay ko meno chikamagi na gina po kaya konspano e ka petsimeta kanachi cha ho kas ana kiwino ni kikosis Jesus Christ. I say thank you. Amen.
Okay, we're just waiting for the drum group to come in, finish their smoke. I've asked them to sing a victory song for day school survivors. Because this was 115 years in the making, that we've been abused, and there's quite a few of us pass on every year, every day, and we survived. So with that, I will ask the drum group to go ahead. Thank you very much. Thank you, drum group. Before we get started, I just want to give just a quick history on on the class action, on how it, on our version. It all started back in 2009, as I mentioned earlier, and we followed the class action because the day school survivors were left out of the Indian Residential School Agreement, and so that is the reason why we're here today. You know, to bring good news to you people. It's to benefit you people, and we've been going through this for many, many years, and I'm proud to say that that if it hadn't been for Spirit Wind, myself, and the late Gary MacLean, who really pushed it through, I honor that gentleman with my heart, and you know, I miss him. Anyway, with that, I would like to introduce our legal team here from Gowling, WLG out of Ottawa, Jeremy Bouchard and Robert Winogrand. They will take it over from here, and I need to say no more. Thank you.
Thank you, Ray, for that introduction. Firstly, just wanted to apologize for the lateness. We ran into a bit of a traffic jam down the street, but thank you for coming out tonight. Thank you for having us and taking the time to come and listen to us. I'll just say, first wanted to acknowledge the opening comments. Thank you very much for that. Acknowledge the drummers. Very good feeling to hear that drum. It's very powerful and moving, so it was very nice. Thank you very much for all of you. My name's Jeremy Bouchard, and I'm one of the lead counsels on this file. I just wanted to start by saying that what we normally have is a presentation with a number of slides so you can follow along what we're saying, what we're saying and talking about. We don't have that here for technological reasons, so we'll make that available though for people to get electronically, and maybe we can get copies of that somehow sent out. So what we wanted to do is talk today about the class action. We call these information sessions, where we come and we provide as much information as we can about the class action. And so that's what we're going to do. We like to, if possible, save questions to the end. We're happy to answer questions. We like to keep those to the end because our presentation does cover a lot of ground. So sometimes the questions that come up are questions that we do answer. Our presentation is, it's about 15 or 16 slides generally, goes for about 45 minutes to an hour, just to give you a heads up. And we provide as much information as we can. So this, my colleague, Bob Winogrand, will provide you with a quick background about ourselves, and then we'll head right into the presentation. I just wanted to say it's nice to have a good-sized crowd here. It's always good to have a lot of people come out and listen. I'll say then just about myself, really quickly, high-level background. My name's Jeremy Bouchard. I've been involved in this file since Gowling WLG was first retained by Gary MacLean back in 2016, and since then I've been involved in every aspect of it. I would say that I am very happy to be here for today. I'm from Southern Ontario. I'm Mohawk from Six Nations of the Grand River. That's sort of my background. I went to school there, born and raised, went off to Ottawa for education purposes, became a lawyer, and started working out there, worked for several years before I transitioned into working at Gowling WLG with Robert Winogrand. I have to say, to acknowledge my dad, or he would not be happy with me, my dad is Ojibwe from Gull Bay, which is a community north of Thunder Bay. And so the combination of the two makes me an Ojimo. I'm very happy to be here in your territory today. I love Winnipeg, and it's particularly nice out today with the sun beaming down, so it's very nice. I'll just say, other than that, I work in Ottawa. I have a practice that spans across Canada, which includes Manitoba. I work exclusively in the area of Aboriginal law, or I think they call it Indigenous law now. So that's where my practice is. It's focused on that. I work out of the Ottawa with a fairly large group, including Robert Neeginan, who will introduce himself as well.
Good afternoon. I wanted to say thank you as well for the invitation, for allowing us to come to you with information. We hope it's helpful. And I wanted to thank Ray Mason in particular for organizing this event. And it's a real pleasure to be here. We're really happy to be here to be able to share with you information and the status of the action, and we'll be happy to answer questions. We're going to stick around afterwards if people want to come up and speak to us in private. So just 60 seconds on my background. I've been practicing law since 1984. It's a long time. I started out as a war crimes prosecutor. I prosecuted Second World War crimes and then modern war crimes, and then was asked to join the Indigenous law section in the Department of Justice, where I did a number of things, but one of which was I had a hand in creating something called the Specific Claims Tribunal. And that's where I met my friend Jeremy, and together we decided to go to Gowland WLG, the firm we're at now. We've been there for a number of years, and we're happy and proud to say that we represent First Nations across the country in all kinds of different types of claims and in different capacities. So what we'd like to do is we would like to take you through a general overview of what this action is about, and then get into the specifics. What are Indian Day schools? And almost as importantly, what they are not, what this action does not cover. I want to talk to you about class actions, just 1 minute on what they are generally, and then get into the specifics of this class action, because class actions are not ordinary things. They're not ordinary litigation. So I'm going to talk a little bit about what makes them extraordinary. I'm going to give you some specifics about what we're talking about. How big is this class? What are we dealing with? What are the harms and so on? We're going to talk to you about compensation. What kind of numbers are we looking at? What's the burden of proof? What do you need to establish when you're filing your claim? I want to talk to you about where we are in the process. As you sit here today, where are we in this process, and what still needs to be done? There are still a number of steps before we implement this settlement. We're going to talk to you about the outreach that we've done so far and the outreach we're going to continue to do, and then we'll open it up for questions at the end. So I'll ask Jeremy now to give you an overview, and then we'll get into the specifics.
Great. So what I wanted to talk about then is sort of just a little bit of the background of the claim. I think Ray spoke into it perhaps previously and mentioned earlier a comment about it as well. What I wanted to do though is just, from where I'm speaking from, just to let you know, I am, as well as Bob, and we have a large team as well of lawyers with us, behind us, the certified class counsel for this class action. We were certified on July 21st, 2018 as class counsel. And so we've worked very closely with the class representatives, and that included Gary MacLean. And we just, Ray mentioned as we opened, but we just have to say a lot of this, we would not have got to this point without a lot of the hard work and determination that Gary MacLean put into this. Is an advocate of family members and survivors across Canada. He advocated strongly, so we are honored to have the opportunity to carry on to complete his legacy. I just wanted to mention that. This action then, Gary MacLean versus the Attorney General of Canada, this is an action, as Ray mentioned, started in 2009. It was started in Manitoba in 2016. After it had languished for some time, Ray and Gary came to us and said, what can you do? How can you help us to advance this? And so it's at that time that Bob and I became involved as lawyers at Gowling WLG, and we looked at how we could advance this in a manner that was, as my partner says, aggressive. We really looked at this as a situation where we had an aging population. And Gary always mentioned that, how many people were passing it. And so we knew there was a sense of urgency to this. So it started in 2009 is when it started. Gary used to tell a story. I know that there were a lot of people involved in this coming forward. But for Gary, one of the stories that he told us was about a time when he was sitting with some friends, and he talked about his experience at a day school for the first time. And he talked about the type of abuse that had happened, generally what he had witnessed and what had happened to him. And it was the first time that he was with a group of individuals who opened up and told their story. And it's really at that time for him that he realized how big this was, how many people were impacted and harmed. And that's really, for him, was a big moment for him when he really moved forward with this, of course. So this is in action, a class action against the federal government. There's no other parties. It's only against the federal government for its role in the control, operation, management, and administration of what are called federal Indian day schools. These are the schools, as previously mentioned by Ray, that were excluded from the Indian Residential Schools Settlement Agreement. We know that a lot of people at that time put forward claims and were denied, and a lot of people asked questions, why aren't these schools included? And so they are now included. They are now being dealt with. And so I think that's an important point. Ultimately, what this action is looking for is justice for those individuals who attended, people who we've called and defined survivors, because when you hear a lot of the stories, for a lot of people, they did survive this experience. And we'll get into some of those. And it also is intended to seek justice for family members. And we'll speak about how that is a part of this class action.
So what are Indian day schools? Typically, they are the 1 or 2 room schoolhouses, almost always on reserve. And there are a couple of exceptions, but almost always on reserve. These are schools that were established and funded and managed by the federal government. The federal government, as Jeremy said, is the defendant, the only defendant. And what we've heard, we've done a lot of community sessions from Victoria to Halifax to the north, and what we've heard in all of our sessions was that the harms that these students suffered were the same kinds of harms that residential school students suffered. Physical abuse, rampant physical abuse, sexual abuse, psychological abuse, and damage to language and culture. All of these harms, all of these elements are part of this claim and are all compensable. And I should tell you that we have a list of schools. There are about 720 schools. That list is public, available for anyone to look at. And the point is that this is not a closed list. We ask communities, if you have different information, if you have information about a school that is not on the list, but was a federally operated day school, we want to hear from you. Tell us the name of the school and any other information that you have, photographs, report cards, and so on. We will take that information and we will research it. And if it turns out that it is or was a federally operated and managed day school, we will add it to the list. So in a nutshell, that's what this action covers. about 720 schools nationwide. We are class council for every school in Canada. But there are a number of areas that the action does not cover. And so what Indian day schools are not.
So I just wanted to speak then really quickly about a couple of key points here, just because for us, we want people to have accurate information, correct information, so that you are able to make informed decisions. So I think what I wanted to say is, we've already mentioned how federal Indian day schools were not residential schools. They were in general separate institutions. So they were often separate buildings. They were the schools where people attended by day only, returning home by night. Only in exceptional cases, weather generally related issues, would someone, have we heard of people who stayed overnight. But in general, children attended and returned home at night. In terms of their relationship with the Indian residential school system, in general, they use the same curriculum and they use the same teaching methods, including discipline. So in a lot of cases, it's really the only distinguishing factor, and we've heard this on multiple occasions in communities throughout Canada, the only difference between residential school and day school for a lot of people was the fact that you got to go home at night. But in terms of the actual treatment that you receive day to day, the level of abuse, a lot of people have said it was very similar. Day schools then, federal Indian day schools, I want to make this point, are not provincial schools. So there is a distinction. I know that some people, there is some confusion around this, but schools that were operated solely by the province, often not in First Nation communities. So these are the communities where people would have to leave their home community often and go and attend outside of their home community. These are provincial schools. Provincial schools are not included. It's something that if somebody would like to consider, it's something that can be initiated in a separate action. In terms of other class actions, I think it's important to mention Godfredson. That is a separate class action. Godfredson is a class action that was started out in BC, and what it concerns is those students who attended an Indian residential school by day and returned home at night. If people fall in that situation where they attended a residential school by day only, returning home at night, there is another class action called Godfredson, and you would be included in that.
In the ordinary course, when a person sues another person or a company sues another company, that's ordinary litigation. Well, what happens if, as in this case, you have over 100,000 people all making the same claim? You can't have 100,000 lawsuits because, of course, it would end up in complete gridlock. So the vehicle that the justice system has come up with is called the class action. So in effect, all 100,000 and more people are in fact making the claim, but that class, as it's called, is represented by representative plaintiffs. Gary MacLean was the lead representative in the action before he passed away. So the representative plaintiffs represent the class, but in effect, all of the members of the class are making the claim and are entitled to compensation. That's generally speaking how a class action works. Now, when we took the file over in 2016, a short time ago, we looked at the material and we really had to start at the beginning. We redrafted the claim, filed it in a different court, and we had to start doing the kinds of studies that would give us an idea of what we're dealing with here. So we first retained an actuarial firm. How many people alive at the time that would have attended a day school? Question one. Next question we asked this expert was, from that moment forward, from the moment of the report forward, how many people would pass away every year that had attended a day school? How many people would not even see that small measure of justice as we move forward? And so what he came back with was this. As of the day of the report, at the end of 2017, the estimate of the class size, this expert estimated the class size to be between 120 and 140,000 people alive at that point in time that would have attended a day school. So you can see that it's an enormous class, much bigger than residential schools. Question 2, the numbers vary year to year, but approximately 2,000 people per year pass away as we move forward into the future. 2,000 people who would have attended a day school every year pass away as the years move forward. And so that's one of the key reasons that we moved so aggressively to find a resolution in this matter. Even though the class size is so large, there are still 2,000 people every year passing away that won't see a resolution, that won't see even a small measure of justice. So the two classes that we've defined in this class action are the survivor class and the family class. The survivor class is anyone who ever attended a federally operated day school. It's as simple as that. If you attended a federally operated day school, then you're automatically in the class, and we automatically represent you as class counsel. And in our travels, in all our community presentations and forums that we've attended, we know from the stories that we've heard that it wasn't just the people who attended the schools that suffered the harm. Certainly their families suffered the harms as well. Our representative plaintiff in Quebec, Mariette Buckshot, tells the story that her father attended the day school in Maniwaki, Quebec, near Maniwaki. He suffered some tremendous abuse and in turn inflicted a lot of harm on his own family. And so we have defined the second class as the family class. These are family members of individuals who attended a day school. Two classes. Survivor class, those who attended. Family class, family members of those who attended. The compensation is different depending on which class we're talking about, and we'll get into the details of that in a moment. But those are the two classes that we've defined in our action. I want to speak to you just 1 minute about a technical matter, but it's important to understand. It's called the class period. The class period is the period of time during which the defendant is liable. So it has a beginning and an ending. So what's the time period that Canada is on the hook for compensation? In residential schools, it was easier. Residential schools opened and they closed. So the class period started when they opened and they ended when they closed. But in our case, the majority of these schools are still in operation. How do we figure out when the class period ends? When does Canada's liability end? And so in researching the schools, what we learned was that administration and operation of the schools transferred in many of the cases. Some burned down and some closed, but in the majority of cases, the management and operation of the schools transferred from the federal government to the nation itself. And so when that process was complete, when the entire management and operation of the school passed away from the federal government, that's the end of the class period. And so you can imagine for 720 schools, it happened different in every case. So we had to look into every single school, look at the history of every single school, and determine when was that process complete? When did management and operation of the school pass? And we did that. So in the public materials, the materials that are public now, there is a list of schools, and one of the columns in the list is either the closing or transfer date, and that is the date on which up till that point is when the government of Canada is liable to pay compensation. That's called the class period.
So I just wanted to mention then, I wanted to talk now about compensation. I think that's a pretty key piece of this litigation. And so what I'll talk about now is compensation for the survivor class. The survivor class being those individuals who attended a eligible Indian day school. And as Bob mentioned, it's referred to as Schedule K of our settlement agreement. And you can find that at indiandayschools.com. That's where all of our information is publicly provided. It includes all of the documentation going back from the very beginning of this class action. You'll find all of the material there, including the settlement agreement. So, compensation. Survivor classes, I previously mentioned, are those individuals who attended an eligible school. I should note, just because, I just wanted it to be clear that this settlement agreement, this class action, includes First Nations, Métis, and Inuit. It's based upon attendance at an institution, so it does include everyone who attended. It's not just open to First Nations, it is inclusive, so I just wanted to mention that. I think that's an important piece. So, compensation. I think what I would say is that when we first were retained on this file in 2016, May of 2016, we looked at this from many angles. We thought long and hard about how we would approach this. There's a couple of things that really stood out for us. One of the things that we really wanted to do was talk to students who attended. We wanted to hear from people who attended a school to tell us about their experience, to tell us about what it was like and the harm that they impacted. We traveled to communities across Canada. We talked to survivors, we talked to leadership, and people told us stories, and they told us what they wanted to see in a claims process. I think that was really key, is that we received direct input on what this claims process should look like, but I think also importantly what it should not look like. So we did go out and receive that feedback, and there's a lot of things that came out of those discussions. A lot of people mentioned the fact that the process under the independent assessment process was a long process. They talked about how legalized it was, how hard it was to go through that process. They talked about the challenges of going through that process and about how individuals were harmed going through that process, re-traumatized, having to tell their story again. And so we had all of this information, we listened, and from that we worked to develop a claims process. So I think the thing that we heard though universally across the nation was that in every community we went to, everyone had a story about some measure of harm that they experienced at the school. Everyone shared a story or talked about a situation where they were physically harmed by the teaching staff, whether it be a father, the nuns, or any teaching staff, and in some cases, other students. They talked about that as if though it had happened yesterday. I think a lot of people we've talked to as well talked about the psychological impact of events that happen at these schools, so witnessing violence. So a lot of people who attended talked about being hit with a ruler, a textbook, anything that a teaching professional could find, and how they were really physically abused and harmed through this process. And it's quite universal. We've had individuals who've talked to us who've disclosed that they were sexually abused as well. So we know that happened in these institutions as well. And then we also know that there was a significant impact as well on language and culture. I think Gary told a story about his first day at day school and how he only spoke his own language, and within the first 5 minutes of attending school he was quite happy about this, and when the nun spoke to him in English, he responded in his own language, and he was punished. He was strapped within the first 5 minutes of being at school, and it was a traumatic experience that he recounted frequently, and so we know this happens. So we took the position going into these negotiations that everyone who attended should receive direct compensation. Our position was always that federal Indian day schools were harmful places. They were inherently harmful, and merely attending, you were exposed to harm. We've talked to people who were physically harmed, and when we explained to them how that wasn't right, it was like a light went off, and they said, wow, that wasn't right, that that teachers were allowed to hit us like that or physically harm us. So, you know, for us, we wanted direct compensation for everyone who attended. And so that's what this process will provide. In terms of the compensation, everyone who attended an eligible school will be entitled to compensation, direct compensation. We also heard about how long it was to go through and complicated it was to go through the IAP process. So what we've designed is a paper-based process. We wanted to make this as simple as possible for those people who elected or chose to go through this on their own. It is a paper-based process, and the ideal was that we wanted to make this a simple process, a user-friendly process, so that if an individual really wanted to, they could go through this process on their own or with minimal assistance, with family, friends. That said, if they do require assistance, legal assistance, culturally appropriate mental health support, we are there to provide that. From a legal perspective, what we are doing is ensuring that if those people who need that help, need the legal assistance, it is available to them at no charge. I think that's a real key thing, is that as part of this process, we will not be taking compensation from survivors. If somebody is awarded an amount through this process, lawyers, in particular ourselves, are not allowed to take fees from survivors. And that was something that we heard directly in our consultations across Canada, was the desire for a process where if people went through it, they didn't have to pay legal fees if they didn't want to. And so that's what we've developed. It's based upon a range of harms, levels 1 through 5. Levels 1 through 5, level 1 starting out at $10,000, and level 5 being at the high end of extreme harm, worth $200,000 in compensation. And there's a number of progressive steps in between as you would move up. I think one more point before I pass it over to my colleague Bob is it'll only be a single payment regardless of how many schools you attended. So we know in some cases some people attended one-day school and maybe they moved to a different community and they may have attended a different day school in a separate community. In those circumstances, what we're looking for is the identification of the most serious harm that that individual may have suffered. And that's how their compensation will be assessed. I'll just pass it over to Bob.
I just want to quickly give you a flavor for the type of harm that's being described, particularly in level 1. And we're often asked, well, what do I need to do to prove my claim? How do I prove it? Where do I get my school records and so on? I guess the first point I want to make is that, and this principle is built right into the settlement agreement, there is a presumption of honesty and accuracy. When someone fills out an official claim form, they are presumed to be truthful about the description of the harms they suffered. There will be no cross-examination, period. In addition, it's hard to imagine, but this process is drastically different from the IRS process and certainly different from a court process. So there are the types of evidentiary things that you hear about do not apply in this process. So if you have school records, terrific. That establishes your claim and no further questions asked. If you have medical records, if you have dental records, But we're very well aware that in many, many cases, none of these records exist. School records are spotty at best, and some, frequently people don't keep that kind of thing. Schools burned down, they're not available. Medical records, maybe somebody who suffered severe harm didn't go to a doctor. Dental records, missing, and so on. Medical records are destroyed after a number of years. That will not defeat your claim. There is a presumption of honesty. If you don't have your school records, your medical records, or any other document that's required, the alternative is a sworn declaration that this is what the school you went to and these are the harms that you suffered. A sworn declaration. That establishes your claim. I want to give you a flavor for the type of harm we're talking about, and then the type of validation that's actually on the grid that is being asked to approve by the court. So level 1, this is the $10,000 level. Jeremy mentioned there are 5 levels. They start at $10,000. That's level 1. Level 2 jumps to $50,000. Level 3 is 100. Level 4 is 150. And level 5, the most severe harms, is $200,000. And as you can appreciate, as you go up by levels, the severity of the harm is increased. And the language in the description tells you the kind of harm that's being contemplated. So for example, level 1. This is the lowest level, $10,000. The harm that's being considered here is this. Verbal abuse. For example, mocking, denigration, humiliation. So these are the insults that students who went to day schools are very familiar with. The degradation, the hitting, this is the verbal abuse, the degradation of being called names, and any other type of verbal abuse that students suffered in school. That's level 1. In the alternative, physical abuse, described as including but not limited to unreasonable or disproportionate acts of discipline. And so this is the hitting with the yardstick, the strapping for speaking your language, the slapping, kicking, any other kind of physical abuse that students suffered while attending these schools. That's the description of the type of harm that's being contemplated at this level. Validation criteria, what do you need to show, especially at level 1? The claim form, and it hasn't been officially, the process hasn't started yet. We'll get into the steps in a moment, but when the official claim form comes out, you will see that what it requires is your information, name, address, phone number, school that you attended, and then there is a description of harms, as I've just read out to you. You will be asked to check off one or more of these harms and declare, I'm at a level 1, check. You sign, your signature has to be witnessed, just the signature, not the information, so there's still a degree of confidentiality. And that's the form, that's the claim. Any other information that you have, like a report card, a photograph, notes, anything else, is extra and goes to prove your claim, but not absolutely required. The absence of those things will not defeat your claim. So that's the kind of process that we designed. That's the kind of process that we were told by communities, in particular Gary and Ray, that this is the kind of process that's respectful of community members, because respectful of survivors, that they will not be put through the cross-examination, the challenge. Nobody's going to be challenged on their harm story, and nobody will be charged a fee. That's the process we've designed.
So I think just in closing on that piece there, the other point I would say and stress is everything about this process is confidential as well. Everything that you submit is confidential and will never be disclosed. In terms of any records that are developed at the end of this, those records will be dealt with however the applicant chooses. So if they would like them returned, they can have them returned, or they can have them destroyed. The records will remain confidential though. Just quickly on estates, I think what we've heard is that we are quite aware that most of the day school survivors represent an aging population. In one community we went to recently, the average age of the individuals who came to listen to us was 86. So we know that it's an aging population, and we know that I can say on almost every presentation we go to, we have people who talked about loved ones who recently passed away, and how unfortunately they will never see any measure of justice. And so what we would say to that is, as part of this process, estates will be able to make application under this process. So a person a loved one who has passed away, it will be possible for their estate to make a claim on their behalf. And in terms of how far we can go back, what I would say is that there is a general limitation period of 2 years. In general, across Canada, you have 2 years to commence a claim against a party. And so what we did is we looked at when this action was first started, which was in 2009, and we went back an additional 2 years. This was all stuff that we had to negotiate. And so we are happy to say that it will go back as far back as 2007. So if you have a situation where a deceased loved one passed away in between now and July 31st of 2007, their estate will be able to advance a claim on their behalf through this process. Compensation principles, and we're at slide 9 of about 16 right now. Compensation principles, I just really wanted to say very briefly, when we started to look at drafting a settlement agreement and we looked at this, what we wanted to do was include a couple of key principles in the settlement agreement. And those principles I'll speak to are principles that parties interpreting this settlement agreement have to abide by. So that includes ourselves, Canada, individuals, the claims administrator. Everyone will have to interpret this in accordance with these principles. So some of the key principles in the claims process, for example, include expeditious. So we want it to be a process that delivers timely results. It's going to be quicker than IRS. Cost effective. We really wanted to have a process that was cost effective in the sense that if an individual did not want to incur legal fees, they could do that through this process. Even so, if they do require legal assistance through this process, Gowling WLG as class counsel will have those resources available at no charge to individuals. User-friendly, we've created an application form that we believe will be easy to navigate for most people, and if they do require additional assistance, that assistance will be made available to them at no charge to them. Lastly, culturally sensitive. We know that's important. We know that what we want to do is have a process that is respectful of the individual and understands the needs and concerns of that individual. And so as part of this, we have maintained that the claims administrator will be required to have culturally sensitivity training for all individuals who will serve as a touch point with claimants. So including everyone up, we would like to make sure that everyone understands the importance of being culturally sensitive. Another point, and I think this is what we were able to achieve as part of this, is we really wanted to limit the likelihood of re-traumatization for individuals. And what I mean by that is across Canada, what we heard when we spoke to survivors is, will we have to tell our story again to an adjudicator or be cross-examined? And for us, we knew in speaking with individuals that that was inherently harmful for someone. For someone to have to tell their story, to have to dig up those kind of details, for some people who suffered severe trauma as a result of this process, it's really hard for them to go through a process where they have to go and explain this to a third party, to an adjudicator, or be cross-examined. So we have included language in the settlement agreement that speaks to reducing the likelihood of re-traumatization. I think that we went a long way towards that by ensuring that no one will be cross-examined on their claims application. And finally, and Bob already mentioned this, the class members in submitting an application are presumed to be acting honestly and in good faith. And so these are all principles that we think really provide a process that we think is fair and will respect survivors as they go through this and limit their re-traumatization. We have baked these principles into the settlement agreement, and so it's a very good thing, we think, in terms of going forward and having these principles in the settlement agreement. Compensation process.
I want to give you a flavor on how this process will actually work on the ground. Many of you know that next week, starting on Monday, the 13th, going to at least the 15th, there will be a hearing here in Winnipeg, and we will be asking the federal court to approve this settlement. And it's the duty and the function of the court to determine whether the settlement is in the best interests of all class members. It's not enough that we have reached a settlement agreement with the defendant, the Government of Canada. The court still needs to be satisfied that it's in the best interests of all class members. And so that will be happening next week. If we are successful and the court approves this settlement, part of what the court does is appoint an administrator. It's not us, it's a large company that will administer the claims process on the ground. So how will that look? I've already mentioned that there is a claim form. We tried to keep it as simple as we could, and it depends on what level people identify themselves at, but this claim form is meant to be as user-friendly as possible. So if you're making a claim, you will look at the claim form and see that you're asked to select the level that you think you're at. Are you a level 1 up through 5? And you base that on the description of the harm in the grid. And what will happen is you'll say, I'm at level 2, for example, because the harm that's described there, that's the harm that I suffered. That's what I went through. And you will identify yourself as level 2. You will put that claim form into the administrator. The administrator will not challenge your description. The administrator will not say that didn't happen, or that doesn't sound right, or there's something wrong with that. That's not the function of the administrator. The administrator looks at the description of the harm and sees whether it matches the description on the grid. If it does, that claim is then sent for processing. It's that seamless and that user-friendly. Now, someone might identify themselves at, for example, level 3, and the administrator will look at the description and say, well, actually, I think that's either a level 4 or a level 2. So a different conclusion than what the claimant identified themselves at. If it's a higher level, there probably won't be a problem because it's a higher level and more money. But what happens if the administrator comes back and says, you're not at a 3, in our view, you're at a 2. There is misinformation that's circulating that there is no appeal. You can't fight this. And the truth is, the reality is that even though it's not called an appeal, there is a process for reconsideration, and it's at 3 different levels. So if you receive a decision from the administrator that you are at a different level than you originally identified yourself at, you have the right, a claimant has the right to ask for a reconsideration. There'll be an opportunity to provide additional information to demonstrate why you're at the level that you said you were at. And if the administrator comes back and says, well, I read your additional material, I still think you're at this lower level, there is another opportunity to ask for a third-party assessor. Third-party assessor will also be appointed by the court. And in the case where the third-party assessor delivers a result that the claimant is unhappy with, there is still the option of what we're calling the exceptions committee. And that committee has a number of different functions, one of which is to look at fact scenarios where, although they don't fit squarely within the process, there's still some resolution that needs to happen. So 3 different levels of reconsideration. Now, at these, during this process, it may very well be that a claimant requires legal services, that there are jurisdictional questions or other types of legal questions that arise. And we as class counsel will be there to assist anyone who needs legal assistance in this reconsideration third-party assessment process. We are class counsel and we will be there to assist. I mentioned the exceptions committee. Not only does the exceptions committee consider claims that don't fit squarely within the process, but in addition they have a number of other functions. People come to us and say, well, our day school is not on the list. And it should be, because it was a day school. I've already mentioned that we do the research. But in the event that that school ends up to be a federal day school, the exceptions committee does a report and sends it back to the parties, Canada's lawyers and ourselves as class counsel. And we then reconsider it. If it is in fact a federal day school, it's put back on the list, or it's put on the list. In addition to that, there is also the dates issue. You heard me speaking about the class period. If people attended a school during years that don't fit within the class period, that's also the subject of a report by the exceptions committee. Are there exceptional circumstances? Are there facts that dictate that this claim should be satisfied? So there are a number of different steps, and as class counsel, we'll be there to assist when legal issues arise.
So I just wanted to speak now about the family class and the compensation component. The compensation component for the family class is different than the compensation for the survivor class. As you can imagine, the number of people who comprise the family class is quite large, which would include brothers, sisters, spouses, grandchildren, aunts, uncles. It's a very large component. So there will be no direct compensation for family class members. But what we were able to do instead is we negotiated an amount, and that is $200 million, that would be paid by the Government of Canada, subject to court approval of the agreement, of course, into a fund, and it's called the MacLean Legacy Fund in honor of Gary MacLean. And so what this fund will do is it will fund 4 key components. Normally I'd have an overhead slide that would lay these out quite nicely. But the $200 million MacLean Legacy Fund will be used for 4 components. The first one being healing initiatives. I think it's really important for family members and survivors as well to have access to culturally appropriate healing initiatives that are community-based. And so a significant portion of those funds will be used for that purpose. Secondly, language and culture. We certainly know from experience talking to individuals that there was a huge impact on language and culture. I can't say how many people talked about going into school and only knowing their own language, and by the end of it, they did not know their own language, they knew English, and they talked about the impact to their family was that they did not teach their son, their daughter, their children the language for that very reason, to protect them from some of the harms that they had experienced as a result of knowing their language and exercising some of their traditions. So cultural and language revitalization will be a second component, a significant component of that. Thirdly, what we wanted to do was have some measure of funding available for each community that was directly impacted by the day school experience so that they could have some sort of a community-based commemorative event. Something where the community could have an event. We've said in the community, and we've said in those circumstances where there is a large off-community component, there should be something in the city as well. In a city where if there's a large component of particular members, that should be available in the city too, to have a commemorative event. And we've heard people talk about having, whether it's a feast, a ceremony, or some sort of a community event, that the community members come together to talk about it, to commemorate that there has been a settlement of this action. And finally, I think very significant component. We have heard across Canada how people need to tell their story. For some people, not all, they really need the ability to tell their story, and that's an important part to their healing journey or process. So the truth-telling form is something, what I would call something a little leaner than the Truth and Reconciliation Commission, but it will be a body that travels both nationally and regionally to hear stories from survivors. Survivors will be invited to attend, to share their experience, their story if they choose to. It's not going to be required. If people want to come and share their experience and tell people, we're going to have this set up so that people are invited to come and do that. It'll be in an environment that is safe and respectful, and permits people to tell their story and to meet with other class members. Also important to that, though, I think, is it will serve as an educational component as well. There's a large component of non-Indigenous people who may not necessarily know what happened at day schools. And so we think it's important that this serve as a broad educational function as well for people who don't know the hardships that people went through at a day school. So that's a significant piece as well. Turning over now to the current status of the action.
So as we sit here today, where are we in the action? In June of last year, the federal court certified this as a certified class action, which just means that the court agreed with us that this is the proper subject matter of a class action. This is rightfully a class action. Certified Gary MacLean and others as representative plaintiffs, and certified Gowling WLG, Jeremy and I and our firm, as class counsel. This is the only certified class action in the country related to day schools. A few months after that, of some furious, I think it's fair to say, negotiation, on December 6th, Gary stood with the minister outside the House of Commons and announced that we had reached an agreement in principle. So all of the key elements were agreed to at that point in time. We had to work out the other details of the settlement agreement, but as of December 6th, we had an agreement in principle. In February, the week after we visited Gary in the hospital, he passed away, and so was not able to see the ceremony and the announcement that we had in fact reached a settlement agreement. We had signed a settlement agreement on March 12th of this year, a few weeks ago. But that announcement was made in March. At the same time, we filed our materials, and we are now in the notice period, which is once the materials are filed with the court and made public, all of these materials, the settlement agreement, the list of schools, and all the other materials are now public online at indiandayschools.com for people to look at and voice their support or their objection. And we're in that process now. And that process ends next week when we're in court, and the court will then hear statements of support and statements of objection. And the court will decide whether this settlement is in the best interests of all class members. If the court approves this settlement, it will appoint an administrator, as I mentioned, and it'll do a number of other things, third-party assessor and so on. There's an appeal period after the court's decision, And after that appeal period, there's an implementation period. So in terms of timing, if there are no appeals, or if appeals are dealt with quickly, then the timing, the estimated timing, is sometime in the fall for the process to get started. The administrator will begin dealing with the claims at some point in the fall. That's the timing we're looking at. So, we still have a number of things to do. We need to get the court to approve the settlement. We will continue, Jeremy and I and others will continue to make community visits to keep communities informed of the progress that we're making, any developments that communities need to be aware of. We're going to continue this. We'll also continue making presentations in terms of legal issues when the legal issues arise as class counsel. We've asked every First Nation and as well as other communities and organizations to appoint point persons so that we can deal with point persons in each community. And we've got an overwhelming response, and we are dealing with point persons. They deliver information to us from the communities and organizations, and then we in turn are able to brief them on the latest developments. And that's just one of a number of different ways that people can communicate with us. We have registration forms. People have registered with us. I think we have close to 40,000 people registered with us already. And all that means is that you're registered so that we can communicate with you. It's not the claim form, it's just so that we can communicate with you. So when the official claim form does come out, we will be able to send it to you directly if we have your email, if we have your address, or if we have your phone number. We'll be able to communicate with you directly. Continue to make community presentations. We hope that the process will start in the fall, that the administration will start in the fall. So I just wanted to say thank you for listening to us. Hope we've answered some of your questions, and we'd be happy to answer more if you have more.
So just before we do that, what I wanted to say as well is I just wanted to say that this is a large class action, and we have set up a number of communication channels. We have a website, indiandayschools.com, and we have a Facebook site or page, MacLean class action. Sorry, I'm not on Facebook myself, but we do have a lot of channels of communications to share information. We have a toll-free number too, which is 1-800-539-3815. It's a toll-free number. We are experiencing high call volume right now. So if you do get an answering machine, please leave a message. Someone will return your phone call. I just wanted to emphasize that. The other piece too is I wanted to explain the difference really quickly between the application form and a registration form. There seems to be some confusion out there. Let me just say that right now, if you have done nothing, you've missed nothing. There is no real hard, fast deadline that no one missed anything at this stage. So what I would say is we have a registration form right now. It's something you don't have to fill out. It's something that we use as a communication tool. So right now, I think the number is more towards like 45,000, close to 50,000 the last time I checked, of people who have registered with us as class counsel. And we use that to share information. So we do provide people who've registered with us updates, information. And when, as Bob mentioned, when the court approves a final application form, compensation form, we will then be in a position to send that directly to you if you are registered with us. I think I just really wanted to make that point, that there is a difference between the two. The deadline of May 3rd, there was some communication around that too. And really what that was is part of this process, individuals are entitled to write a letter of support or a letter of objection. That was due on the 3rd. No one has to do it, but you're able to do that if you'd like, and that was the May 3rd deadline. So other than that, though, there were no other deadlines. The application will come out after court approval. So right now, with respect to the session that the settlement approval hearing that's happening on May 13th, 14th, and 15th here in Winnipeg, that's really the next big event. So we would ask you to stay tuned for that, and we will probably see some of you there. So that's it for me. I just wanted to say that.
How many of these you got?
We got a few.
Oh, I gotta bring it down for short guys like me. Not that low. Anyway, they have a few the information cards where they can contact the council, you know, if you wish. We're going to give the people, you folks, a chance to ask questions. If you have any questions, please come to that mic and line up. You know, if you have any questions, come to the mic in the center there, and the council will try to answer your questions. Okay.
Hi there. Uh-oh. I don't know, does it have a switch on it at all? Uh-oh. Well, while he's working on getting that ready, I will say we have information cards up here too, which has a number of information points on it if anyone wants one. They'll just be over here on the chair if anyone has to step out early.
Yes.
Okay. Cards?
Good evening.
Okay, go ahead. Go ahead.
Hi, my name is Clarence. Clarence Sumner.
Hang on for First Nation. 1 second. Go ahead.
Hi, Jeremy. Hi. My name is Clarence from Fairford First Nation.
Yeah.
I'm just a little confused with my community and the years that are being compensated. We have Upper and Lower Fairford for our community. And one of them is 1970, another one is 1950 to 1966, another one 1951 and 1963.
Yes.
And then they also give us 5 years in 1977 to 1981. What about all the years from 1970 to 1977?
So on the list of schools, what I can say about that, you're asking about the...
I'm only asking for my reserve.
Yeah.
It's confusing for us, especially for me, because I got a lot of people that are from my community from 1970 and then down. You guys are going to compensate. So what happened to all the years from 1970 to 1977? You guys are going to be missing out a lot of baby boomers like myself, or people that are younger than me, I guess. Like I qualified for 1977 to 1981.
Yes.
So what about the years that they were transitioning from the day schools to the big school in my community? There's 7 years missing, 1970 to 1977.
Yes.
That's quite a bit of years.
Yes. So what I can say about that is each community will be different in terms of when a start and end date will be, and for each school it can be different. Bob mentioned in our presentation just briefly about how the cutoff date, the closing date, is determined by essentially two factors. Sometimes the school closes, sometimes it's burned down, but in some cases, the control of that school passed to the nation. So the Bend, the community itself, may have taken over control of that school at that point. So what I would say is in this case, if it's saying that there's a cutoff date, we have a research report that shows that the administration of that school passed to the nation at that date. So that's what likely happened. But if you feel that isn't the case, I would invite you to contact me. Let's talk about the date that the community thinks it is, and if we can get a little more information on your end from that, we'll bring that forward.
Okay, and last thing I just wanted to say was 1977 to 1980 when my school was called Stedman School. But I graduated from that school in 1988, 7 years later, and my grade 12 diploma says Stedman School. So can you guys kind of try and help us out there in Fairford and find out when exactly the cutoff date and all this was? Because we're missing a bunch of years.
Yeah.
I'm saying 1970 to 1977, that's 7 years.
Yes, it's significant.
Yes, please.
So I'm like I said, I'm happy to work with you on that. And so let's touch base before I leave. I'll only say that the way it would have been determined is based upon research that shows that it closed or the control of it transferred to the nation. So we'll have to take a look at that.
But do you understand what I'm saying?
I do.
1970 to 1977 years. Who was in control of our schools then? But yet you guys go on to compensate us for 1977 to 81.
Yes.
I don't understand where those 7 years, why
Sure.
those 7 years are being
So
cut.
what I'll do is I will get you the answer to that. Okay?
Thank you. I appreciate it.
Thank you. Hi there.
My name is Ann Thomas. I'm from Vegas First Nation. I'm not sure if I'm understanding like the legal part. If I was to be part of this class action, is it my understanding that my children and grandchildren, further generations cannot sue the federal government for anything from intergenerational effects? Is that true?
So as part of this process, in terms of who's included, certainly the family class member is a key component, and yes, that is true.
So when you're talking about the family stuff, what do you mean by, when you say there's the $200 million, is that for across Canada?
Yes, so the question is whether,
Family members, which basically means like thousands of people, so they all have to be part of that 200 million, right?
yeah, so in terms of the 200 million, the ideal is that the 200 million, yes, would be used to fund programs nationally, so across Canada that are directed at healing. So yes, looking at the intergenerational impacts, and that would include an impact on language and culture. Now, what I will say is that there are a couple of things that we've done here that allows this corporation, it'll be a non-for-profit corporation that administers these funds, but it will have the power to invest. So it will have the ability to increase that amount.
Because as I recall, being the daughter of a residential school survivor, I was able to access counseling, but I was only able to access 10 sessions, right?
Yes.
Once I got to the 10th session, I felt like that's not enough, but I was cut off.
Yes.
That's why my question about the family members being able to access that $200.
Yes. Yes, family members. The family members will be able to access it through programming. We are working on developing all of those right now. We are working in consultation with leadership across Canada through engagement sessions like this to look at developing what would be the most appropriate, and this will be made available.
Now, the other question is, when you were talking about the assessor, when they're going to choose like what level you're at,
Yes.
what kind of qualifications does that assessor have to decide whether or not I'm at a level, if I'm claiming for a level 3 and he says, no, you're only at a level 1, what kind of qualifications does he have to make that decision?
Yes. So right now what we've done is there are a number of what they are called claims administrators. So the claims administrators, there are a number of firms that do claims administration in Canada. And so the one that we have looked at is Deloitte, and they will have qualifications in the sense that they have done claims administration like this in the past. They have done large claims administration process where they are receiving paper applications and making determinations. And so they will have adequate training to deal with these based upon prior experience as well. And I have to emphasize too, there is a robust review process here too, where it won't just stay with the claims administrator. There will be other opportunities to have a decision reviewed if somebody's not happy with it. I'm gonna have to, this has to be the last one because we have a lineup behind you.
Last one. I know that there are a lot of other lawyers going around, trying to get people to be part of this.
Yes.
Now, do they have the right to charge people to be part of the claim, or can they just come to you guys and there's no charge at all?
So that's an excellent question. You mentioned about other lawyers, I guess, getting people to sign on with them. So the way this action has been structured is that if an individual who is part of the class comes to us, they will not be charged any legal fees. And so anyone who wants to charge legal fees has to have it approved by the court. So they can't just enter into these agreements without court approval.
So the lawyer that I know who's charging people,
Yes.
how do I find out if they've registered or?
So right now there is no other lawyers that are certified. We are the only certified lawyers for this class action. So
I know a lawyer, she's charging people $25 for her assistance.
yes,
Is that illegal?
it's something that has not been approved by the court.